judgment in the matter of the Crown on the application of the Spitalfields Historic Building Trust against London Borough of Tower Hamlets and another.
Lord Sales will hand down the judgment.
This case is about the way in which applications for planning permission are determined by a local authority or its planning committee. Applications for planning permission for major developments may be determined by the full council, involving all the elected council members, but often applications are allocated to the planning committee of the council to decide, involving just the few members who are on the committee. Many local authorities have standing orders which govern how the business of the council and its committees should be conducted. If an application for planning permission is complex, or there are matters which need to be investigated and resolved before a decision is made, it is common for the application to be considered at a series of meetings at which additional information is introduced for review. The issue in this appeal is whether it is lawful for a local authority to have a standing order which says that when a decision on an application is made at the final meeting of such a series, only those councillors or committee members who have attended the whole series of meetings may vote on the application. The appellant says that such a standing order is unlawful and an unjustified interference with the right of councillors or committee members to cast their votes on matters of concern. The application in this case is for planning permission to redevelop an old brewery in Spitalfields for certain commercial uses. The application was made to the London Borough of Tower Hamlets as the local planning authority. The application was allocated to the Planning Committee of Tower Hamlets Council. The appellant is the Spitalfields Historic Building Trust, who are opposed to the application. The application first came before the Planning Committee at a meeting on the 27th of April 2021. 5 committee members were present. Presentations were made in favour of and against the application. The committee voted to defer consideration of the application while some inquiries were made. The next consideration of the application was at the meeting of the committee on the 14th of September 2021. By that point, the composition of the committee had changed and only 3 of the members who had considered the application at the meeting in April were present. The council's standing orders stipulated that only those 3 members were entitled to vote on the application, since only they had been in attendance at the previous meeting when the application was considered. They voted 2-1 in favour of granting planning permission. The Appellant Trust applied for judicial review of the grant of planning permission on the grounds that it had been unlawful for the council to adopt standing orders to exclude any members of the planning committee at the time of the September meeting from voting at that meeting. If all members of the committee had been allowed to vote, the result of the application for planning permission might have been different. The Trust's argument about the unlawfulness of the standing order was rejected at first instance and again by the Court of Appeal. The Trust now appeals to the Supreme Court. The Supreme Court unanimously dismisses the appeal. The statute which governs the functioning of local authorities is the Local Government Act 1972. By Section 106 and by paragraphs 39 to 44 of Schedule 12, that Act confers powers on the local authority to make standing orders regulating the conduct of council proceedings and of the proceedings of its committees. Giving the words of these provisions their natural and ordinary meaning, they cover the making of a standing order of the kind under review. Adopting such a standing order serves a proper purpose. It means that planning applications are actually determined by councillors or committee members who have heard all the arguments and fully understand, and can be seen to fully understand, all the relevant issues. The court can see no good reason for adopting a different, narrower interpretation of the relevant statutory powers. The Trust sought to argue that a council member's right to vote on council or committee business is a fundamental right which can only be removed or qualified by a clearly expressed provision in primary legislation. There was no such provision here, only a general power to make standing orders to regulate the conduct of council business. A fundamental right to vote could not be removed by a provision in standing orders. The court does not accept this argument. A council member's entitlement to vote is not a fundamental right personal to the member. It is an entitlement conferred on them as a member of a public body, which is required to be exercised in ways which ensure that the public body acts in a lawful and effective manner. For example, If a council member was biased, or had predetermined some matter calling for a decision, or had a conflict of interest, they would have to recuse themselves from voting in council or in a committee of which they were a member. If they did not, and they participated by voting, the decision taken would be unlawful. Therefore, their entitlement to vote is not fundamental and inalienable, but a right which is qualified by the public objectives of the local authority and the need for its functions to be exercised in a lawful way. The power to make standing orders is not unlimited, but is itself qualified in that it has to be exercised for good reasons and for proper purposes to support the lawful and effective exercise of the council's functions, including in relation to the conduct of the business of granting planning permission. It is accepted that the standing order in this case has been promulgated for good reasons and for those purposes. Adherence to the standing order promotes the transparency and legitimacy of decision-making by the planning committee when deciding on applications for planning permission. It ensures that the persons voting to make the decision are properly informed about all relevant matters. It also minimises the risk of later challenge to decisions on the basis that members who did not attend all the relevant meetings at which the application was considered were voting not on the basis of the merits of the proposal, but on the basis of some biased or predetermined views. For these reasons, the Court holds that the standing order is lawful, and this appeal is dismissed.
Thank you. The Court is now adjourned.